Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector webinar series for caregivers. Today's topic is Wills in Maryland, sponsored by Prince George's County Government and the Department of Family Services.
Hi, I'm Darlene Powell. I'm one of the staff attorneys at Community Legal Services of Prince George's County. Today I'm going to talk about wills in Maryland. What exactly is a last will and testament? Essentially, a last will and testament is a document that sets forth your wishes and how you would like to have your property distributed at the time of your death. Who needs a last will and testament? I would say every adult needs a last will and testament. If you don't have a last will and testament, then the state of Maryland, in accordance with current Maryland law, will decide who your property and valuables go to at the time of your death, as opposed to you making that decision. Also, the court will decide who will be your personal representative or executor and handle matters pertaining to your estate rather than you making the decision which you would have made if you had a last will and testament in place. So that's essentially what happens if you don't have a last will and testament in place. What is property in the context of a last will and testament? Essentially, property is anything of value. It can be real property, such as a house, a condo, or it could be personal property, like your wardrobe or your jewelry and so forth. What property can be disposed of under a last will and testament? Either personal or real property can be disposed of under a last will and testament. However, there are certain exceptions to that. For example, in Maryland, if you're a husband and wife and property is held in title as tenants by the entireties, then that particular property would go to your surviving spouse automatically by operation of law. So, for example, if you and your spouse own a house together, it's titled in both of your names as tenants by the entirety. Immediately upon death by operation of law, that property would go to your surviving spouse. Additionally, if you had bank accounts that were set up in that manner, they would go to your surviving spouse as well. Those are general rules with respect to what can and cannot be disposed of under a last will and testament, although there are certain other rules depending on certain very specific situations. So it's always important to consult with a lawyer if you have any doubt. Personal representative. What is a personal representative under a last will and testament in Maryland? Essentially, a personal representative is the executor. Most people are familiar with the term executor. The personal representative is the person who carries out your wishes under the will, under the supervision of court personnel. Factors to consider when choosing a personal representative. You should choose someone who you know well. You should choose someone who would be competent to handle your estate. You should choose someone who's good with dealing with financial matters, or alternatively, someone who knows to employ the help of an accountant, an attorney, or other professional if they are unable to handle things on their own. The selection of an alternate personal representative is important. If your personal representative is unwilling or unable to act on your behalf for some reason, then your alternate personal representative would step into place. If you have not chosen an alternate personal representative, then the court would have to make the decision, and the person the court would then appoint as your personal representative may not be the person who you would have chosen. Co-personal representatives. Some people want to have co-personal representatives where two people are acting jointly. You can do that. I don't think that's the best idea. With co-personal representatives in general, if the two of them cannot agree, then it may end up in court litigation because there'll be a deadlock and certain decisions aren't going to be able to be made in a timely manner. Probate. In Maryland, what court office do you go to in order to open an estate? In Maryland, you would go to the Register of Wills office, which is at the courthouse in your county of residence. When should an estate be opened? As soon as possible after your death. What is probate? Probate is the judicial or administrative process of overseeing your estate by the court. Your estate consists of everything of value that you're distributing under the will. Probate is the process which the court oversees to make sure that your personal representative is doing exactly what they're supposed to be doing under your last will and testament. For most things, the personal representative is going to have to obtain court approval. For example, if your personal representative is selling property that's part of your estate and distributing it to your heirs. Does all of my property have to go through the probate process? If you have a trust set up, then most of your property is probably part of the trust, in which case you may not have to go through the traditional probate process. Additionally, as I mentioned earlier, if property is titled as tenants by the entireties on a deed or a bank account or so forth, that property generally would not be part of the estate that would go through the probate process. Additionally, if property, whether real or personal property, is titled in two names of people as joint owners with rights of survivorship, that property may not have to go through the traditional process. What about minor children who inherit under a will? Typically, you're going to want to appoint a trustee or other individual to manage the inheritance of any minor children. Can you appoint a guardian to raise your minor child or children under a will? You can designate in your will whom you would want to take care of your minor child or children. However, that is not binding on the court. For example, if you're divorced and you want your sister to raise your minor child or children in the event of your death, the court is probably going to give preference to the children's biological father and not to the person who you designated in the will. However, if the biological parent is unfit for some reason, then your wishes as expressed in your last will and testament may become very important and may give the court some guidance as to who might be the best person to raise your children. Proper execution of a last will and testament in Maryland. Under current Maryland law as of May 2020, you need 2 adults over the age of 18 years to witness your last will and testament. The 2 witnesses, among other things, are attesting to the fact that you're of sound mind, also that you're voluntarily signing the document, and so forth. The witnesses should not be anyone who's named in your last will and testament, whether as an heir or whether as a personal representative or trustee. Storage of your last will and testament. You can store your last will and testament in a safe place in your home. Perhaps if you have a home safe or other secure area to store your last will and testament, you can certainly store it at home. You can store it in a safe deposit box at a bank. However, your personal representative may not be able to gain immediate access to the original will if it's stored in a safe deposit box, or you can store it in a vault at the courthouse. The Register of Wills office charges a one-time $5 fee to store your last will and testament in a secure fireproof vault. I recommend that you store it in a vault at the courthouse, that's probably the safest or one of the safest places to store it. In terms of your last will and testament, no one will read your last will and testament prior to the time of your death. If you want to make changes to your last will and testament, you can retrieve it from the storage at the courthouse, or you can designate an attorney to withdraw the will from the storage at the courthouse on your behalf. But you or a designated attorney would be the only two people generally who can take the will out during your lifetime. If you have any further questions about last wills and testaments or the probate process in general, feel free to contact Community Legal Services of Prince George's County at either the telephone number listed below or through the website listed below. Thank you. This presentation is part of Dementia Friendly America's initiative, specifically Dementia Friendly America, Prince George's County, Northern Sector. You can learn a lot more about Dementia Friendly America and all the different communities involved in this movement online. Dementia Friendly America, Prince George's County, Northern Sector has virtual support groups. Please consider connecting with one of these groups. Also, there are monthly email newsletters to keep you informed and provide important information. There's also an upcoming webinar series. Dementia Friendly America Northern Prince George's County has a YouTube channel now, and you can view educational videos on a wide range of topics. For additional information, you can contact Sharon Johnson at the phone number or the email address listed on this slide. Thank you.